counsel, Mr. McDowell, Mr. King, Joe King, who is an assistant Ohio Attorney General, was appointed as special prosecutor in this matter, and he is present as well. Mr. Uible entered a plea of guilty on October 25th to a single count of tampering with records in violation of tampering with records, a misdemeanor of the first degree. I have sent the matter for sentencing today, obtained a pre-sentence report, and have provided copies of that pre-sentence report to counsel. There's an initial matter I need to resolve as well, and on November 5th, private citizen Tommy Bixler filed a request to be treated as a victim in this matter so that he could speak at sentencing. And just so the record is clear, Mr. Hicks also filed a request, a petition to be treated as a victim in this case. And at the hearing on October 25th, I went through a number of reasons why he would not be found to be a victim in this case, and found that he was not a victim under Article 1, Section 10A of the Ohio Constitution, which is Marcy's Law. Mr. Hicks, pursuant to that statute, or the constitutional amendment actually, filed a petition with the 12th District Court of Appeals challenging my decision. He challenged my decision that I was erred in not permitting him to be a victim. I erred in charging him, or requiring him to pay the $7 court cost fees that were incurred as a result of the petition that he filed. And he also requested the 12th District Court of Appeals admonish me for behavior inconsistent with any reasonable policy as it pertains to victims. And the 12th District Court of Appeals affirmed my opinion, my decision, further upheld my decision to order Mr. Hicks to pay the court costs, and further found that there was no reason to admonish me as requested by Mr. Hicks. So therefore, Mr. Hicks is not obviously a victim in this case, and he cannot speak. The 12th District did not address Mr. Bixler's request to be treated as a victim because it was not before the court. It was filed certainly after the sentencing date, or after the plea date, as I indicated, on November 5th. And before I address that petition, so that there is no misunderstanding of what I said on October the 25th, I'm going to replay a pertinent part of that, October the 25th. I'm going to replay a pertinent part of that record. And Mr. Lyles, if you play that, I have set that to ask Mr. Lyles to play the audio recording, and we need to set it. It was at 9 o'clock, 9:42 and 35 seconds is that precise on the recording. So if you can cue that up. For over 2 years, and again, direct approximate is not defined. So to look at the usual definition of those terms, and I don't find that Mr. Hicks has been directly and proximately harmed. The person who was directly and proximately harmed was the fact candidate himself, Mr. Uible. If it had been Mr. Hicks's petition, and Mr. Uible was a circulator, and he did that, then Mr. Hicks probably would have been a person that was harmed. I was a member of the Board of Elections for 8.5 years from about 1990. As I indicated at that time, Mr. Hicks, addressing Mr. Hicks's petition, I indicated that had Mr. Hicks been a candidate for the commissioner's seat, and Mr. Uible had circulated Mr. Hicks's petition and tampered with it, which eliminated all the signatures on that petition, then perhaps Mr. Hicks would have been a victim in that case. Mr. Bixler, in the second paragraph of his request, sets out the basis for why he is to be considered a victim. And I just read that into the record. In the plea hearing on October 25, 2019, Judge Ference, you denied Chris Hicks' request to speak. At about 4 minutes into the audio of the hearing, Judge Ference, you stated that a reason he could not speak was that he was not a candidate for the office of commissioner. He puts in parentheses and in quotation marks, he was not in any way a candidate for that position. Your Honor, I was, and it's emphasized, I was a candidate for that office. I was, emphasized, running against Mr. Uible. I was, emphasized, a part of the original petition protest to the Claremont County Board of Election. Judge Ference, I was a victim even by your own remarks. And obviously, with what you just heard, that's taken totally out of context and tends to underscore how you can take something out of context and spin it however you wish to spin it. I clearly made the decision that Mr. Hicks was not a victim under Article 1, Section 10A of the Ohio Constitution because he was not directly or approximately harmed by Mr. Uible's conduct in this matter. As to Mr. Bixler, he clearly remained a candidate. This is an unusual kind of circumstance in that, on the record, I mean, it's clear I can take judicial notice under Evidence Rule 201 that Mr. Uible's position on the Board of Commissioners was up for re-election in 2018. There was a Republican primary in 2018, and there were 3 Republicans running for that position. One was Tommy Bixler, one was Claire Corcoran, and of course the other was the incumbent, Mr. Uible. And Mr. Bixler's petitions obviously were not circulated by Mr. Uible. Mr. Uible did not in any way participate in Mr. Bixler's petitions, and Mr. Bixler's petitions were all approved, and he had sufficient number of signatures to remain on the ballot. And I cannot find Mr. Bixler was directly and proximately harmed as a result of Mr. Uible's conduct. In fact, just the opposite is true. Mr. Bixler was directly and proximately benefited by Mr. Uible's tampering in this case, because as the Board of Elections rightfully decided, they had to exclude his entire part petition, not just those additional names that had been signed, but the entire part petition. And as a result of those signatures being excluded, Mr. Uible did not have sufficient signatures to be placed on the ballot. He obviously was not on the ballot. And Mr. Bixler's chances of succeeding in the primary were increased instead of decreased because Mr. Uible was no longer a candidate, and all Mr. Bixler had to do was to defeat Ms. Corcoran, and it became a one-on-one instead of one-on-two. That is certainly a benefit, not harm. So I would find that Mr. Bixler is not a victim under Marcy's law, under Article 1, Section 10A of the Constitution. He's not a victim under the current statutory scheme set forth in Chapter 2930 of the Revised Code as well, and he having no rights as a victim to speak before this hearing anyone that he wishes to appoint as his representative, which, by the way, coincidentally, as Mr. Hicks will also not be permitted to address the court at this sentencing. And as I've indicated, the 12th District Court of Appeals reviewed this, and at the third page of their decision noted as follows: Hicks is not a victim who has a right to be heard at Uible's upcoming sentencing hearing. As noted above, pursuant to Article 1, Section 10A-D of the Ohio Constitution, the term victim means a person against whom the criminal offense or delinquent act is committed, or who is directly and proximately harmed by the commission of the offense. Hicks is neither, and he is, the 12th District indicated that the court properly determined that Hicks was not a victim as the term is defined by Article 1, Section 10A-D of the Constitution. He has not been directly and proximately harmed by Uible's conduct any more or less than any other citizen of Claremont County, Ohio. We'll proceed with sentencing at this time. Mr. Keene, on behalf of the state, do you have any position?
Yes, Your Honor. Ultimately, the state defers to the court, but I do want to identify a few issues and facts that relate to mitigation, extenuation, and aggravation. As the court noted, the harm in this case, if any, was self-harm. The state contemplated that mitigation in resolving this case. This is why it wasn't a felony. This is why it was a misdemeanor, because of the Board of Elections action. As far as extenuation, according to the PSI, Mr. Uible claimed it was an honest mistake and that he did not think his actions were in any way illegal. I believe it was a mistake, but calling it honest might be disingenuous considering Mr. Uible's history with the election law in Claremont County for the last decade or longer. And lastly, as it relates to aggravation, in accordance with 29-12 factors, I believe 2 are triggered. 1, Mr. Uible held public office or a position of trust, and the offense was related to that office or position of trust. And secondly, that his reputation, occupation, or office facilitated the offense. So given those 2 factors to be considered, I believe his history, of course, he was a public official, that did help facilitate the offense.
Well, I would just indicate one thing. You said under 29-12?
Yes, sir.
Okay. This is a misdemeanor, so 29-12 is not applicable. 29-22 would be applicable.
I do understand, sir.
All right.
Thank you.
Yeah, Mr. McDowell.
Thank you, Your Honor. Your Honor, first, I think the court was wise to have a pre-sentence report prepared in this case. It showed what we all believe to be true, but it's always nice to confirm those facts. Mr. Uible is 58 years old. He will be 59 years old soon. Mr. Uible informed me that he had no criminal record and that, in fact, he had no speeding infractions, even, or criminal traffic infractions in the last decade. The pre-sentence investigation confirms that fact. His last traffic infraction was in 2003. So what we're dealing here with is someone who has really, in essence, no criminal record whatsoever. He is married. He has a very stable family life. He's been married for 24 years. He has 1 grown adult daughter. He has been fully cooperative in this investigation. That's something that really doesn't come out in the pre-sentence report. And I think the prosecutor will agree that Mr. Uible sat down, submitted himself to an interview by the BSI, that they talked to him, that he was cooperative with them with respect to everything in this case. So I think it's very fair to say that he's been fully cooperative in this matter. He is also a college graduate. He graduated in 1983 from Purdue University with a degree in mechanical engineering. He also has a certificate from the University of Cincinnati. So we're dealing here with an educated individual, somebody who can think through what they did wrong and also move forward with their life in a good manner. The prosecutor felt that it was aggravating that this was an abuse of a position of trust. I would submit to the court that the offense does not necessarily have to have been committed by an individual who was an office holder, that these could be office seekers. And in this instance, Mr. Uible was seeking office. He just happened to be an incumbent in the office. Mr. Uible also owns several businesses in Claremont County. He is a successful businessman. He employs many people in Claremont County, and he has for many years. The pre-sentence investigation concluded that he has no history of substance abuse, no mental issues, and I bring that up because when the court looks at whether someone is amenable to rehabilitation, the fact that they have mental issues or they have substance abuse is a factor that usually goes against them if they do, but he does not. With respect to the offense, I'd like to also put that into perspective. The court is aware that this deals with the declaration of candidacy form. Mr. Kidwell was the circulator of this particular petition. 5 signatures were later added to the petition at Mr. Uible's request with his knowledge. But these 5 signatures were superfluous as to the number of signatures that Mr. Uible would have needed in order to run for this office. That is, if we take those 5 signatures out, he would have had enough signatures. The court should also be aware that all 5 of the individuals who signed onto the petition were indeed proper. That is, they were Republicans, that they lived in Claremont County, and the dates that they signed the petition were accurate. That is, this is not an instance where Mr. Uible forged anyone's signature. All the individuals who signed onto the document did indeed want Mr. Uible to run for this office. One of the signatures was found to be not valid, but later, as part of the investigation into this case, a BCI went to that person, and the reason it was found not to be invalid is because the Board of Elections felt that it didn't look like the person's signature. The BCI went to that person and they showed him the petition and they said, yes, that is my signature. I did sign that. I didn't want Mr. Uible to be a candidate for this office. As the court is well aware, the law with respect to these documents is that if there's an issue with it, the entire thing is thrown out. As a result of the added 5 signatures, the entire petition was thrown out, and Mr. Uible was not able to run for re-election as a county commissioner, and therefore he lost his position and the salary that went with that office. I would also indicate that this has been a well-publicized incident, that Mr. Uible's reputation, and this is not something he can hide from. This is all out in the public. Mr. Uible is remorseful for this. This is not something that will happen again. He is not a person who will be before this court or any other court again. He had a good record before this incident. There's no reason to believe that he would ever do this or anything like this again. So when we look at whether somebody is rehabilitatable, certainly Mr. Uible is entirely in that category of persons who is both remorseful and able to be rehabilitated, and is not someone who this court will see again. Thank you, Your Honor.
And Mr. Uible, what would you like to say?
Your Honor, for the record, I'd like to correct my counsel in that my wife is here, but we've been married 34 years, not 24 years. But I understand what I've done is illegal. I've apologized to family and friends and the public as well. And I've made changes such that this will not happen again.
Anything further? Well, I have reviewed the pre-sentence report in detail, including documents that were submitted on behalf of Mr. Uible. Consider the appropriate statutory sections that are required for sentencing. Taking what Mr. King has said, which I agree with for the most part, and also with what Mr. McDowell said as well. This is a self-inflicted situation, but it could have been easily avoided. All Mr. Uible had to do actually was just go to the Board of Elections, get another part petition, fill out the top form as any candidate has done, have those 5 individuals sign it, and we wouldn't be here today. But he didn't do that, and that is a serious mistake. The pre-sentence report, the investigation provided to the court by the state, and as you've indicated, Mr. McDowell, these were not forged signatures. Every signature on all the part petitions were appropriate. Everyone signed them. The mistake was clearly altering it to allow those 5 individuals that he wanted to sign petitions, sign petition. And the Board of Elections was certainly correct in dismissing or rejecting that entire part of the petition. Mr. Uible has certainly been a law-abiding citizen. He has some speeding tickets in his lifetime. He only has one other citation, and that was a dog got loose from his property that he owned, and he was cited for having a dog running at large, and that's it. He is obviously a candidate, and I find will certainly be eligible for probation, and his sentence will be as follows. I'll place Mr. Uible on a period of probation for 6 months. It will be effective October 25th, 2019, the date that he entered his plea of guilty. One of the conditions the prime condition of his community control or probation is that he not be convicted of any criminal offense, federal, state, or local. If he would be convicted of a federal, state, or local criminal offense, he would need to report that conviction to the department, the probation department, within 24 hours or the next business day. Any conviction would occur on a business day, so if it was on a Friday, he'd have to report it to the probation department on Monday. I will impose a fine of $250. That fine will be paid to the clerk of courts. I will order Mr. Uible to pay the court costs incurred in this matter, with the exception of the following costs. Number one, he will not be required to pay the $7 that Mr. Hicks paid on the petition, because that has been paid. Mr. Hicks also filed, after I made my decision that he would not be a victim, a document that he called pre-sentence information. That contained 93 pages of documents, and the clerk is required to charge $1 for every page that is filed with the clerk. And Mr. Uible will not be responsible for that. Mr. Hicks will be responsible for paying $3 related to that particular document. It will not be a reporting probation in that he has to report. It will be court monitored. The only thing he would have to report would be if he is convicted of any federal, state, or local criminal offense within the next 6 months or so. Anything further, Mr. King?
No, sir.
Just no doubt.
No, Your Honor.
Thank you. Good luck, Mr. Uible. Thank you.
Your Honor, does he need to report to probation today?
No, just no.
Good to go. Thank you, Your Honor.
Court will be in recess to consider other cases that are on the docket.